Avoiding double patenting, Terminal Disclaimer 101. Let's dive right into how you can protect your intellectual property. Understanding and avoiding double patenting is crucial for maintaining the validity of your patents. The terminal disclaimer is your essential tool. What exactly is double patenting? Simply put, it's the impermissible practice of claiming the same invention twice, or claiming an obvious variation of an invention already patented by the same applicant. The core concept aims to prevent an unjust extension of patent rights beyond the statutory term and to avoid multiple enforcement actions for the same invention. There are two main types: statutory double patenting, which is based on 35 U.S.C. 101, and non-statutory or obviousness-type double patenting. Double patenting rejections typically occur when you have multiple related applications claiming similar subject matter, often stemming from parent or continuation applications. The solution to non-statutory double patenting is the terminal disclaimer. Let's explore how it works. A terminal disclaimer is a statement filed with the USPTO that disclaims the portion of the term of a later issued patent that would extend beyond the expiration date of an earlier issued patent. You need to file a terminal disclaimer when your application receives an obviousness-type double patenting rejection against an existing patent to overcome the rejection. The process involves submitting the correct form and paying the required fee, ensuring you meet all legal stipulations for linking the patents. According to 37 CFR 1.321, the disclaimer must ensure that the patent is enforceable only for the period that it is commonly owned with the reference patent. The terminal disclaimer ensures the later patent expires on the same date as the earlier patent, preventing unauthorized extension of patent rights. Filing a terminal disclaimer is more than just a formality. It has significant strategic implications for your patent portfolio. Crucially, a terminal disclaimer links the patents for enforcement and licensing. If the patents are no longer commonly owned, the disclaimed patent becomes unenforceable. For related applications, plan ahead. Maintaining common ownership and filing the disclaimer at the earliest sign of a non-statutory rejection are best practices. To wrap up, understanding double patenting and the role of the terminal disclaimer is vital for all patent practitioners and inventors. The terminal disclaimer serves as a powerful mitigation tool against non-statutory double patenting, securing your patent's validity while ensuring a unified expiration date. Remember, the key takeaway is the importance of prompt filing and maintaining common ownership of related patents to avoid the serious consequences of double patenting.